what is now the Victoria Cannabis Buyers Club, and I'm, I guess, very happy to be here in that we're going to the Court of Appeal of BC on a winning note. As many of you know, last year Justice Johnson of the BC Supreme Court made a ruling in favor of Owen Smith, former head baker of the Buyers Club. The ruling struck down the medical marijuana access regulations, ruling that they were unconstitutional for not allowing patients to make derivatives, that is, cookies, tea, from legal cannabis that they possess. That ruling has been appealed. This Friday, we will be in Vancouver before the Court of Appeal of BC, arguing that the judge, in fact, made the right decision, and that will be led by lawyer Kirk Tousaw, who did an excellent job before Justice Johnson, and we're expecting the same on Friday. So I'll, I think, turn the microphone, as it were, over to Kirk to explain what Friday should look like.
Yeah, thanks for coming, everybody. As Ted said, Friday we're in the BC Court of Appeal. We are the respondents in the appeal. Mr. Smith's the respondent in the appeal. The Crown has taken an appeal of the law and not the facts found by Mr. Justice Johnson in the law. And that's relevant for a couple of reasons. First, it means that there's a standard of review that applies in the Court of Appeal. It's very difficult to challenge factual findings from the trial judge. In the Court of Appeal, it's easy to challenge legal analysis. And essentially what the Crown has said in its filings is that Mr. Justice Johnston misinterpreted Section 7 of the Charter's protections, extended them beyond the boundaries that Section 7 properly covers, and asserted that what the patient witnesses have expressed in their trial testimony was simply a mere preference for a form of illegal treatment, edibles, lotions, topical cannabis preparations, over a legal form of treatment, the dried bud itself. Now, what we've said in response to that is twofold. One is that the Crown is trying to do an end run around the facts. The difficulty with the Crown's argument is that the evidence simply doesn't support it, and neither do the findings made by Mr. Justice Johnson. The evidence in the trial was very clear that these patients weren't just preferring tasty cookies, as it was characterized by the Crown and the trial as well. That in fact they derived significant medicinal and therapeutic benefit from the different products, and in fact the different products work better for them and for the treatment of their critical and chronic illnesses. That was supported by expert evidence, and Mr. Justice Johnson found that in fact things like edibles have a different mode of activation of the human body. When you smoke cannabis or vaporize cannabis, you get a very quick impact because of the ingestion direct pathway to the lungs and to the blood, to the brain. So it works very quickly. It's good for acute pain, for example, because it goes into effect very rapidly. But then just as rapidly, you lose the effects. So there's a spike, a short plateau, and then a drop off on cannabinoids in the bloodstream. Edibles, on the other hand, and this was accepted by Mr. Justice Johnson, it wasn't actually contested by even the Crown's witness below. Edibles take longer to work, but once they begin working, they rise slowly to a plateau of cannabinoids, and that's maintained for a longer period of time. They're good for chronic conditions, edibles in particular. They're good for chronic conditions because they provide a long-lasting effect. And so in another trial, a witness put it this way: if you break your arm, that's acute pain. You want instant relief from that pain. So you can smoke cannabis, for example. But if you live with chronic pain, and you're in pain every second of every day, you don't want to be smoking or vaporizing cannabis every 15 or 20 minutes, particularly if you have a life outside your home and you want to go around the neighborhood, things like that. When you get home from school, you would use edible cannabis, for example. Additionally, topical cannabis is quite different from both of these because topically applied cannabinoids have no psychoactive effect. And so you don't have that sometimes unwanted side effect of the psychoactivity related to both edible and smoked or vaporized cannabis. So the difficulty, I think, with the Crown's argument is they say they're not appealing the facts, and yet, in order to prevail on the main thrust of their argument, they really have to have a appeal and set up a whole different set of facts. And so I say a more rigorous standard of review, applicable factual findings ought to apply. And there simply was no error. These were not seriously contested issues. The second problem with the Crown's position is it's simply wrong on the law. This was not a mere preference situation. What Mr. Justice Johnston decided was that the restriction in the MMAR to dried cannabis only, and therefore smoked or vaporized cannabis, ingestion methods only, was arbitrary. It was arbitrary because that restriction didn't further the legitimate goals of the MMAR or the legitimate goals of the Controlled Drugs and Substances Act, which are essentially to prevent harm. The Controlled Drugs and Substances Act nominally is there to prevent people from harming themselves through the use of controlled substances and protect the health of Canadians generally from the black market of unlawful substances. Now, as a person who understands this issue, I realize that prohibition causes most of those problems. It's not the drugs themselves, but that wasn't at play below. And so let's assume that those are legitimate state goals that are furthered by the prohibition. The Crown was unable to demonstrate below how the restriction of dried cannabis only actually advanced those goals. And in fact, the patient witness's testimony was, if we are restricted to dried cannabis only, we're going to be harmed. In fact, our health is going to suffer. And so a law, a restriction on one's freedoms that doesn't advance legitimate state goals is arbitrary. In Section 7 jurisprudence, the judge so found and struck the restriction down. The Crown largely ignores that portion of the analysis in favor of its argument that this was somehow, the judge said, you would prefer illegal treatment or legal treatment. It's just a mere difference. So I'm fairly confident in our arguments. A little wrinkles been thrown in at the last minute. Yesterday, the Court of Appeal, via memorandum of counsel, indicated that the Court wants to hear from the parties on the issue of standing. Standing is a legal concept. It basically means you have the right to make certain arguments. I think it's pretty clearly established in law that you can have representative standing. In other words, if you're being convicted under a law or a regulation that is unconstitutional, not just as to you, but as to any Canadian, you can challenge the validity of that law in court. And so I'm reasonably confident that we'll be able to prevail on the issue of standing. Not only that, but Mr. Smith obviously had his liberty at jeopardy because had he not been acquitted, he could have been sentenced to a significant period of incarceration for his activity. And the Court of Appeal asked, well, if he wasn't an MMAR license holder, if he didn't have the right to produce marijuana or provide any marijuana to any patients, how does he have standing to challenge the MMAR? My response is quite likely to be, well, it would have been futile for him to get an MMAR license because the activities he was engaged in, making edibles and providing edibles and topicals, weren't lawful under the MMAR. So, in effect, what's the point of applying for a license that's not going to allow you to do that which it is that you're planning to do anyway? So, a little bit of a wrinkle at the last minute, so we're doing a little jumping, a little scrambling to make that argument as well on Friday in the limited time we have available to us. But all in all, it's obviously easier to be the respondent than the appellant in litigation. It's easier to preserve a victory than to try to claw a victory out of the jaws of defeat. And so we're very excited about the opportunity to, again, demonstrate that health cannabis restrictions on the rights of autonomous patients to medicate themselves with a safe and beneficial product like cannabis and cannabis derivatives is something that should be protected by the Charter, and that people like Mr. Smith and all the patients, by the way, should not be in danger of being arrested and jailed for making medicine out of a natural health product that benefits them. subject to any questions.
So if you win the appeal on Friday, the government will just appeal this report.
That's certainly a possibility. There's certain, if it's a unanimous victory in the Court of Appeal for either side, then the losing party has to apply for leave to the Supreme Court of Canada. The Supreme Court of Canada has to decide whether or not it wants to take the case. It's not required to. Thus far, in our 12 years of litigation on the issue of medical cannabis, and I think 3 or 4 leave applications made in the Supreme Court of Canada, that court has not taken a medical cannabis case. So it's showing a disinclination to do so.
So where's the precedent? Where did the precedent stand on that? Can you make things like that?
Well, let me finish the second part of the first question there. If there's a dissent, in other words, if it's a non-unanimous decision, 2-1 either way, you have an automatic right of appeal in the Supreme Court of Canada. Now, I do expect that whoever wins or loses, there'll be either a leave application or an appeal made in the Supreme Court of Canada, and perhaps this will be the case that court takes up to really delineate once and for all what are the boundaries of the right to use medicinal cannabis. And really, it's not just about medicinal cannabis. It's about the right of patients to autonomously decide what they put into their own bodies to help their serious illnesses without threat of criminal sanction. It's more than just about medical cannabis. Theoretically, for example, the government could ban echinacea, the government could ban St. John's wort, the government could ban all these other natural health products and make it a criminal penalty to sell them in this country and therefore deprive patients the autonomous right to use these natural health products that are safe and have been used for millennia. So it's not just a medical cannabis issue, it's really a patient's rights issue and an autonomy issue. As free citizens, what do we have the right to do? In terms of precedent, precedent comes from a number of areas. Precedent in the area of medical cannabis thus far has come principally from Court of Appeal decisions in Ontario. And there's a number of them, as well as one decision in the Federal Court of Appeal. Those are on the lower courts across the country. They're highly persuasive, but they aren't Supreme Court of Canada forward. Precedent also comes generally from Supreme Court of Canada decisions in the area of Section 7, and particularly in the area of Section 7 as it relates to access to health care. And there are a number of such decisions. The Portland Hotel Society case involving Insight is one source. Rodriguez, which was an assisted suicide case in the Supreme Court of Canada, another source of boundaries of Section 7. Jurisprudence, Morgenthau in the Supreme Court of Canada, upholding a woman's right to choose on autonomy grounds, essentially. Another source of significant precedent. And then a case whose name eludes me at the moment, but involving access to health care in the context of access to private health clinics. I've forgotten the name of that case, I apologize, I'll know it on Friday. But that too, those are Supreme Court of Canada decisions that speak to does Section 7 protect autonomous decisions of a fundamental personal nature that are important to the individual? And I say that it does in this area.
Are you not clear on standards? How could you not have standards? At this point, is it because of this acquittal?
No, it has nothing to do with the acquittal. What the Court of Appeal has said is how can Mr. Smith, who did not apply for and did not have a license under the marijuana medical access regulations, how does he have standing to challenge the provisions of those regulations? And standing is an issue that raises its head from time to time in cases, often, for example, in search warrant cases. For example, if you're discovered with contraband in the home of a friend and the police illegally enter the friend's home, you don't have standing to challenge that illegal entry because it wasn't your charter rights that are being protected there, not your home under Section 8 of the charter. So, to date, I haven't seen standing be that much of a problem in these types of cases because Mr. Smith's liberty is in jeopardy. He's being prosecuted under the Controlled Drugs and Substances Act. We challenged the Controlled Drugs and Substances Act, and we further challenge the MMAR, which are promulgated under the Controlled Substances Act. So we say he has direct standing as somebody whose liberty could be taken away to engage in this activity. And further, he has representative standing to stand in the shoes of the patients whose rights are being abridged by this arbitrary, and I say unconstitutional restriction. So I'm with you. When I got the memorandum, my reaction was, well, how can you not have standing? Even the Crown didn't contest standing, and you would have thought if somebody was going to challenge standing, it would be the other side that lost. Certainly wasn't an issue at trial, did not appear to be an issue until yesterday in this appeal.
And so this was from the court?
This was from the bench, yes, from the bench. So perfectly content to deal with it. It may have simply been a housekeeping point. I don't know. But we've been asked to speak to that issue, and we will speak to that issue.
The government should have changed the regulations by now, the regulations, because this is more political. But did the appeal put everything on hold?
Well, the government argued very strenuously at trial after Mr. Justice Johnson made his order striking down these restrictions that it needed a year. It needed a year so that it could respond legislatively to the striking down of these restrictions. We heard a lot of rhetoric about how Canadian safety was going to be compromised, people making extracts were going to be blowing themselves up, people were going to be overdosing, this was going to be a very serious problem, and they got their year. At the end of that year, they hadn't done anything. And so they came back in the court and they asked for more time. They asked for a further delay through the end of the appeal. And Mr. Justice Johnson said, well, you haven't done it, essentially, I'm paraphrasing here, but so you haven't done anything in the last year. I'm not going to give you any more time. You don't seem to be, you seem to be just asking for more time to get an appeal and get this overturned. And that's not one of the reasons you get additional time. You have to demonstrate something beyond, well, we might win an appeal in order to get a suspension of a declaration of invalidity. So that expired. And so British Columbians have been able to, since Mr. Justice Johnson's decision as a patient, you've been able to make your own edibles and topicals. And since the expiration of the year, as a designated producer, somebody who grows and produces marijuana for a patient, you've been able to supply those patients with edibles, topicals, and extract, hashish, resin, and other products. The fact of the matter is that the sky hasn't fallen, as of course anybody who has a sense to do it wouldn't. What's happened is that we've seen patients benefit in British Columbia and benefit in ways that they're deprived of the benefits of if they live in other provinces, because Mr. Justice Johnson's decision doesn't have binding effect outside British Columbia.
You lose your appeal.
Well, it depends on what the court rules. Of course, the MMAR will cease to exist on March 31, 2014. They're being repealed. All production licenses and rights to possess are being taken away from patients. We're moving to a commercialized system of production. And ironically, and I think unconstitutionally, in the new industrial system with its fairly significant quality control standards and its rigorous security standards and all the things that the government of Canada said it needed in place to ensure safety of patients, the government has still chosen not to allow even these commercial producers to make edible products, to make topical products, and to provide trichomes, resin, hash, colloquially, directly to patients, which is an incredible, I think, shame. And it's shameful, really, for the government of Canada to prevent these producers that they're going to license to grow unlimited quantities of cannabis and sell dried bud directly to patients through mail order. They're requiring a ton of security, a ton of quality control, and yet they don't trust even these commercial producers to make things that can be very dose specific, which dried bud really can't be, that can be tailored in terms of contents of the cannabinoids and other ingredients directly to a patient's condition, which again dried cannabis can't be. I think it's shameful that there's no room in the new system for these types of products that benefit so many thousands, perhaps hundreds of thousands of Canadians. Nevertheless, the government has made its choice. And undoubtedly, those restrictions too will be challenged in court at a later time.
Should those decisions be upheld? Somehow, how would you feel?
Well, it's a one-day appeal, so it'll be Friday only. The Court of Appeal will issue a decision at some point after we make the argument. There's no timeline on that. They'll issue it when it's prepared to do so.
So they're probably reserved.
Oh, I'm almost certain they'll reserve it. It'd be shocking if the court didn't reserve a decision. These are fairly contested issues and fairly complicated issues from a charter perspective.
Is the fear that the federal government take edibles, adoptables, and use it from an industrial perspective in places like dispensaries to get it easily accessible?
Well, I don't know that that's a fear. I mean, I think that most people support as many avenues of access to medicinal cannabis products as possible. I think the government should have and should allow these new licensed producers to make topicals, to make edibles. And frankly, I think they should allow patients to do the same thing, because let's not forget, as of today, outside of British Columbia, you're licensed to possess cannabis, medical cannabis. You're licensed to possess it. You take that cannabis that you are licensed to possess, and you put it into a jar of olive oil, heat it up a little bit, stir it around, and then you skim off the plant matter, which is inert, has no medicinal benefit, and all the medicinal benefits contained in the resin glands, which have now gone into the oil. You've just produced cannabis resin, you produced THC. That's a crime. That's a crime for which you can go to jail for 14 years in this country. So it's not just about producers. In fact, it's not even principally about producers. This is about patients. And outside of British Columbia, if you're a patient that uses a non-dried bud form of cannabis, you're breaking the law. You're subjected to being arrested and incarcerated, potentially subject to mandatory minimum sentencing as a result of the government's mandatory minimum sentencing legislation. It's a travesty. It's a tragedy, and it should simply not be allowed to stand.
How much of this fight needs to go on? How much of this fight is about?
Well, the fight on Friday is all about the law. Now, is there a political component to this area? After all, the government of Canada can choose to fix these problems literally with the stroke of a pen. And the fact that it chooses not to, and the fact that it leaves patients in jeopardy of perhaps being sentenced to a mandatory term of imprisonment for turning products that they're permitted to possess and simply taking out inert plant matter, leaving the actual medicinal compounds behind, that you can go to jail for that. It's abhorrent. And certainly, politically, it would be in everyone's best interest, all Canadians, if the laws around medical cannabis were significantly liberalized, and indeed if we just did away with cannabis prohibition entirely and allowed this plant to be treated like what it is, a natural health product with very minor negative side effects and with tremendous and thousands of years of therapeutic benefit potential.
And as you were saying, you do have medical decisions on the precedents that you already decide. It's just the product.
I think that's right. I mean, I think there's a tradition in this country, a common law tradition of access, of informed consent, really. We let patients make decisions about their course of healthcare treatment for themselves. Really, in this country, to the point where you can refuse, as an autonomous being, life-saving treatment and die as a consequence. We're simply asking for the right to be able to ingest a safe and beneficial natural health product that humans have been using medicinally for thousands of years. So I think there's a long history of protecting access to healthcare in this country, and I hope that we continue to expand on that on Friday.
Thank you very much.
Thank you.
How about you, Ted? How did this last year been, with the appeal and feedback? Have you got another day for
Okay, well, things have changed a lot around here as a result of this trial. When Owen was arrested, I believe, 4 years ago tomorrow. There was a 3rd or the 4th.
Right around tomorrow, yeah.
Tomorrow, yeah, it was 4 years ago tomorrow. The club was owned by me. It was called the Cannabis Buyers Club of Canada. After Justice Johnson's decision, the Canada Revenue Agency came here looking for taxes, which I hadn't collected and remitted till that point. My response was to turn the club into a non-profit society, which had been the goal all along. And we did that just over a year ago. We just had our first annual general meeting, and the group has flourished under these conditions. And it's no longer mine. It's something. I'm not on the board of directors. I'm not a paid staff. I'm an author. I work with Hempology 101 and educate the public now. And so I volunteer here, help out any way I can. But it's a true community non-profit organization that's changing as we speak. One of the exciting ways that we've changed has been to include a number of new products, and I have pamphlets here for you of the new capsules. We have 9 different kinds of capsules that we sell now, using different kinds of plants and different methods of cooking it so that they have varying medical benefits. And it's a more familiar means of ingesting for doctors and patients who have never used cannabis before. So we have a number of physicians that are quite happy with this new range of products that we have. And soon on our menu we will also even have suppositories, 4 different kinds of them, different strengths, again to give patients and doctors the broadest range possible of products for them to use for different conditions. And so our club has really taken it upon itself to become world leaders on this matter. All of our products, recipes are online. Our cookbook is fully available. We want to teach the world how to make medicine from this plant, as opposed to the way the rest of the world works, which is what we're fighting, because pharmaceutical companies can sell synthetic THC at $8 a pill right now. And we sell our capsules for 25 to 40 cents. Oh wait, no, our hash capsules are $8. So really, the pharmaceutical industry doesn't need to profit and control off of this plant in the way it does off of normal drugs. We, as Kirk suggested, would be happy to change the law such that these licensed producers and patients would be able to make these products freely without fear of the law. That is our goal in this case. Thank you. Here's your pen. I'm still holding it.